Good morning, everybody. My name is Samantha Broadfoot, KC, and I'm joined by my colleagues today, Miranda Butler and Charles Bishop, who I will formally introduce in a moment. We were expecting to have Fiona Scolding, KC, chairing today, but she's unfortunately fallen ill and we wish her a speedy recovery. To begin with, a few housekeeping points to note. Your microphones are automatically muted, so you will not need to adjust your local settings. We very much welcome questions throughout the session. Please submit them via text in the Q&A section, which can be found at the top or bottom of your screen. If you would like to remain anonymous when asking a question, please make sure you tick the Send Anonymously box before submitting the question. We will endeavour to answer as many questions as possible at the end of the presentations. This webinar will be recorded. You will receive a link to the presentation and the recording shortly after the event concludes. If your connection is lost at any point during the webinar, we invite you to rejoin the meeting by clicking on the original link once more. So let us begin. This is the quarterly recap in public law. I'm joined then by Miranda and Charles. I'll say a few words about each of them before we kick off. So Miranda has a broad public law practice with a particular focus on the rights of migrants and victims of trafficking. She is currently instructed in the COVID inquiry with Fiona Scolding and has recently been shortlisted for the Immigration Junior of the Year at the Legal 500 Awards. Charles practices across the full range of public law landmark, as well as undertaking many judicial review cases in his planning and environmental practice. He regularly acts in strategic judicial review cases, including the wild fish challenge to the government's national strategy to combat sewage discharge into rivers, the successful challenge to the government's implementation of the settlement scheme for EU citizens post-Brexit, and the Gardner case, a test case challenging the government's policies on COVID in care homes at the start of the pandemic. So that's all I'll say at this point. Miranda, over to you.
Thank you very much, Sam. So today I'm going to be talking about 3 different cases covering a range of issues. Each of these cases could probably merit a talk all by themselves. Firstly, I'm going to talk about Every Child Protected Against Trafficking in Kent, which deals with suspended quashing orders. I'm then going to move on to talk about unpublished policies and finish with the public sector equality duty and a little look forward to the legal term to come. So starting with ECPAT, as I'm sure many people here will be aware, this case concerns the situation of unaccompanied asylum-seeking children, most of whom enter the UK via Kent. Unaccompanied asylum-seeking children should be looked after by local authorities for the purposes of the Children Act, but Kent found the rising number of children entering was placing a significant burden on their resources. As a way of managing this, they agreed a protocol with the Secretary of State for the Home Department to accept a limited number of UAS children, leaving the Secretary of State responsible for the rest of them, pending their reallocation within the UK under the National Transfer Scheme. I'm referring to unaccompanied asylum-seeking children not as UASCs, which they often are, but as UAS children, because Mr. Justice Chamberlain, in his very thoughtful judgment, emphasised the need to see these children as the highly vulnerable children they are, rather than treating them as a mere acronym. The children that were not in Kent's care, but who remained in the Home Secretary's care, were placed in hotel accommodation. Whilst they were in children-only hotels, this is the kind of accommodation in which adult asylum seekers are normally placed. They were out with the local authorities' care and weren't treated as looked after children. This created what is essentially a safeguarding crisis. Hundreds of the children went missing, and sadly, a large number of those children remain missing, and many of them are believed to have been trafficked. There were a large number of legal issues raised by this claim, perhaps unsurprisingly, but I've attempted to summarise them here. Broadly, the questions were whether Kent was in breach of its duties under the 1989 Act by limiting the number of children it would receive into its care, whether it was lawful for the Secretary of State to place UAS children in hotels rather than local authority care, whether both bodies were complying with their statutory duties, and whether their agreement under the protocol was lawful. In his first judgment, which was handed down a couple of months ago, Mr. Justice Chamberlain deals first with the fairly straightforward question of Kent's responsibility. Kent conceded that its actions breached its primary duties under the 1989 Act, in particular, its duty under Section 20 of that Act to care for children in need within its area. It therefore followed that the protocol agreed between Kent and the Secretary of State was unlawful, as it resulted in a breach of those duties, and both parties were held to have acted unlawfully in agreeing to it. It's worth noting in this context that in future, the Secretary of State will have powers to accommodate and support UAS children directly under the Illegal Migration Act 2023. However, those provisions are not yet in force, and it isn't clear when they will be coming into force. Moving on to the Home Secretary's responsibility, it was noted that the Secretary of State had no express statutory power to accommodate UAS children in hotels, and in particular, the framework for accommodating asylum seekers under the Immigration and Asylum Act 1999 does not include a power to accommodate children. And while statutory bodies may only act if they have an express basis for doing so in law, the court concluded that the Crown's powers are different. And when exercising Crown powers, a public body can exercise any powers which a private individual could. And furthermore, it was emphasised that where the Secretary of State was faced with children who would otherwise potentially be street homeless, it must exercise those powers to avoid a breach of its positive duties under Articles 2 or 3 ECHR. It's also worth noting that the court said it might possibly have reached the same result under Section 3(5) of the Children Act, which allows for those who have children in their care, but who don't have parental responsibility for them, to take reasonable steps to safeguard their well-being. Therefore, whilst in principle the Secretary of State was allowed to accommodate children, the court placed very tight limitations on this, emphasising that such a power may only be used over very short periods in true emergency situations where stringent efforts are being made to enable the local authority promptly to resume the discharge of its duties. It cannot be used systematically or routinely in circumstances where it's intended or functions in practice as a substitute for local authority care. And the court noted that such an outcome would frustrate Section 20 of the Children Act. And those narrow limitations had plainly been exceeded here. The crisis had really escalated in late 2020, and some children had been accommodated by the Secretary of State for more than 2 years. The court pointed out that there were alternatives for the government. The government had a range of options open to it to ensure that these children were accommodated and looked after, and might have to provide increased funding to allow the local authority to comply with its duty under the 1989 Act. However, one of the unusual features of this case comes not so far as regards the unlawfulness, but as regards the relief that the court granted, because all parties agreed that immediate cessation of the unlawfulness would but not be in the interests of affected children, and may in fact prevent their transfer to other local authorities. Before I move on to talk about relief, it's worth noting that this is very much a live and ongoing issue, and there have been headlines within the last week, one of which I have placed here, that the Secretary of State is still placing large numbers of children in hotels. So after its preliminary judgment in July, the Administrative Court held a further hearing in August, which was followed by a relief judgment handed down on the 1st of this month. The court quashed the protocol between Kent and the Secretary of State, and also part of the protocol regarding the National Transfer Scheme, but handed down a suspended quashing order under a new power within Section 29A(1)(a) of the Senior Courts Act 1989. The effect of a suspended quashing order is that the unlawful act is upheld and essentially allowed to continue until the quashing takes place, and is to be treated, and I'm quoting here from the statute, as if its validity and force were, and always had been, unimpaired by the relevant defect. However, once the quashing comes into effect, the act is treated as having been void ab initio, including in the period between the making and taking effect of the suspended quashing order. And so Mr. Justice Chamberlain suspended the Kent Protocol for 3 weeks to allow for negotiations which would permit Kent to discharge its statutory duty to all UAS children, which it was recognised could not be done immediately. This further hearing was held to ensure that the conditions for suspension had been complied with, and following that hearing, the court granted declaratory relief, confirming the unlawfulness of Kent's actions and those of the Secretary of State, but also listed a third hearing. I'm sure everyone here will note how unusual it is to have 3 hearings in a case such as this, and Mr. Justice Chamberlain was mindful of the criticism that there has been of so-called rolling judicial review. He confirmed that the normal practice should be that there is a single finding of unlawfulness, that relief is granted, and that is the end of the judicial review. However, this was an unusual circumstance where there were long-standing recognised unlawful actions and intractable issues around compliance, which warranted the court's intervention. And he found that these proceedings with active claimant representatives who were assisting the court were an appropriate vehicle to supervise compliance. And in doing that, whilst suspended quashing orders are a new mechanism, he did look back at previous practice in similar cases, such as Client Earth, where the court was willing to grant liberty to apply in a case involving long-standing illegal levels of air pollution. So I've noted here at the bottom of the slide that whilst rolling judicial review is something that we all seek to avoid generally, in some cases where suspending quashing orders are appropriate, a move towards rolling judicial review might be a particular feature that we're more likely to see, and on very rare and particular facts, it may be appropriate. Moving on to another judgment of Mr. Justice Chamberlain, I'm going to talk about MXK and others. This involved the circumstances in which individuals who held limited leave in the UK and who also owed debts to the NHS were being stopped and detained by the Home Office when entering the UK in order to investigate their NHS debts. There was an unpublished policy which resulted in this outcome, whereby the Secretary of State incorrectly and unlawfully directed border force officials that NHS debt may be a basis for cancelling leave to enter or remain, and therefore may also be a basis for detaining individuals whilst making a decision as to whether to cancel their leave. The only basis on which NHS debt can be used as basis for cancelling leave to enter or remain is where an individual has made false representations or material non-disclosures about NHS debt when applying for and obtaining leave. That was not the case here, and so these individuals who had debt in respect of antenatal and maternity care were unlawfully stopped and detained. It was found that the policy was unlawful as it contained a positive statement of law that was wrong or incomplete. In particular, it implied that NHS debt was generally a grounds for cancelling leave. It was also found that the policy was unlawful because it was unpublished. Secretary of State did publish did withdraw the policy shortly before the hearing, but it had clearly been in force for quite some time prior to that happening. Finally, the court also found that the Secretary of State was in breach of her public sector equality duty. There was simply no evidence that she had taken her duties into account. She attempted to rely on equality impact assessments that had been undertaken in the context of introducing charging in the NHS, which was obviously not relevant to this specific policy. It was noted that there was no equality impact assessment done about this policy. I should emphasise the court made clear that the absence of an equality impact assessment does not of itself mean that the PSED hasn't been complied with. However, it may make it harder to show that it's been complied with in substance and with rigour as is required. So speaking about the PSED, we're going to go all the way up to the Supreme Court now, and we're going to talk about its judgment in Marouf, which asked what the territorial scope of the PSED is. This case concerns, once again, the Home Secretary and her vulnerable persons resettlement scheme. You may remember that this was first introduced in 2014 as a scheme for vulnerable Syrians to be resettled in the UK. It has since been broadened, and essentially it works whereby the UNHCR identifies particularly vulnerable individuals, and then they are considered for transfer to the UK by the Home Secretary. This is not a scheme that someone can apply for. It is very much a scheme whereby the UNHCR selects individuals. The claimant in this case is a Palestinian refugee living in Lebanon, and as you may be aware, UNHCR has no mandate in Palestine or with Palestine refugees. They are cared for by the UN Works Relief Agency, and therefore it was essentially impossible for any Palestinian to fall within the ambit of the scheme. And the question was whether the Secretary of State's duties under Section 149 of the 2010 Act could apply to a Palestinian refugee living in Lebanon, i.e. whether it had extraterritorial effect. The court reaffirmed the principle that has been articulated in a number of cases, that there is a presumption against legislation having extraterritorial effect. And the court concluded that there was nothing in Section 149 itself to override that presumption. In reaching that conclusion, the court emphasised the fact that the duties to have due regard to the need to eliminate discrimination and foster good relations was about achieving those outcomes in communities within the UK rather than communities outside it. And you can certainly see in this judgment a concern about a floodgates effect if essentially the whole world might be able to litigate under the PSED. And you'll see at the bottom I've quoted from the judgment where the court expressed its concern that the claimant's argument would confer rights on people all over the world to challenge the decision-making process of a public body exercising its functions if the exercise of the public body's functions affected them. So finally, I just want to put a few cases on your radar for this term. I doubt that anyone has failed to notice that the Miranda litigation is still ongoing. It is listed in the Supreme Court this term, and the Supreme Court is clearly minded to issue a prompt decision. I wouldn't be surprised if we had a decision from the Supreme Court by Christmas, but my predictions have certainly been wrong before, so I wouldn't put money on that. We are obviously going to have the third hearing in the ECPAT case, and it will be interesting to see if any further relief is considered necessary. I'd like to make a little mention of a case of my own, which is upcoming, that I'm doing with Nicola Braganza at Garden Court Chambers, FH versus the Secretary of State for the Home Department. We are arguing that there are unlawful systemic delays in the making of conclusive grounds decisions regarding victims of trafficking, and that will be listed later this term. Finally, whilst it's not a case to watch this term, we've already talked in my section about outstanding provisions of the Illegal Migration Act. Of course, the Illegal Migration Act makes absolutely vast, very widespread changes to the entire asylum system and many systems related to it. there isn't a time frame for most of the Act coming into force. A few provisions are in force related to citizenship and the appointment of judges, but the key provisions are yet to come into force. And I would certainly advise everyone to keep an eye on Westlaw for that. Thank you very much for listening. I'm going to hand over to my colleague Charles now.
Well, good morning, everyone. Thank you, Miranda and Sam, for that. I'm going to focus on some procedural cases that have, or procedural points that have arisen in a few cases since our last session on this. So I'm going to talk a bit about embargo judgment, still lots of case law happening on that, embargoes still being breached. Look at some recent summaries of the correct approach to factual disputes in judicial review cases. Look at some comments in relation to redactions that are being applied in defendants' evidence, especially central government's evidence, and also another recent case on service of sealed JR claim forms. So dealing first with judgment embargoes, this arose in the World Congress case, which concerned the government's actions in respect of cotton produced in the Xinjiang region in China. The substantive judgment was handed down in January, and this case came up more recently because there was a second hearing essentially on the consequences of a breach of embargo. As is usual in these cases, judgment had been reserved following the hearing. Judge took time to consider the case, Mr. Justice Dove, and circulated a draft judgment a few days before it was due to be handed down, subject to the relevant practice direction. The draft judgment also included the usual embargo, prohibiting the contents of the judgment and its outcome being disclosed to anyone beyond the parties and legal representatives, and often there are more bespoke embargoes applied in these cases now, limiting it to senior officials of a particular party, etc. The embargo also referred to last year's very publicised Court of Appeal case in the Council General of Wales case, in which the Court of Appeal gave guidance on embargoes and stressed the seriousness of any breach of an embargo judgment. In this case, what happened is judgment was circulated by the lawyers to the relevant parties, one of which was HMRC, and a policy officer at HMRC who had received a draft from the government legal department then wrote to individuals in the Home Office, the Department for International Trade, who was not the party, and the Cabinet Office and the Foreign Office, both of which were also not parties, and they advised that they'd received the draft judgment, that the result was favourable to the defendants, and when it was going to be handed down. This it became known to GLD later on that day that the embargo had been breached and that parties who weren't supposed to know about the judgment had been told about it. GLD then there was a considerable amount of correspondence, all very urgent, trying to trace down the source of the breach and notifying the parties that the breach needs to be reported to the court and that it needs to be closed down. And the court looked very carefully at the draft email that had been sent. Sorry, the email that had been sent by the government legal department within the civil service, which disclosed the draft judgment, and they stressed that the email had been very clear that this judgment was strictly confidential to the parties and that other named departments couldn't be told, and one of them was the Cabinet Office, who had been told about it. They noted that the email clearly emphasized that responsibility for retaining control over the decision was to remain with GLD, and that GLD needed to be asked before it could be sent to anyone else, even within the own departments. The court noted that this email from GLD also stressed the strictness of the embargo and the potential for breach to give rise to proceedings for contempt of court, either against the relevant government department or the individuals who were responsible for the breach. And the email was also accompanied by a brief document, a sort of leaflet or information sheet that GLD prepares about embargoes generally. And I know we do have quite a number of representatives from the government legal department in this webinar, so I'm sure you're probably aware of what that says. So given that GLD had taken, really quite a lot of steps to ensure that the embargo was properly communicated to the people who needed to know about it, and that it was not to be breached, the court was concerned that it had in fact actually been breached in this case, and they asked for a witness statement from the official who had actually been responsible, and he did give a witness statement, and he said that he had not recognized or understood the full effect of the embargo. He expressed his deep regret that he had not read the instructions properly, which is admittedly quite a candid thing to say, and he accepted responsibility for the breach. He in part attributed it to pressures of work, and one does have some sympathy, because I'm sure he didn't, he had no intention, as far as I could discern from the judgment, of leading to these significant consequences. His witness statement also referred to an HMRC practice note about embargo judgments. So there had also been internal decisions in relation to embargoes that had been going on within HMRC. In light of that, the court said there was no doubt there was a significant breach of the requirements of confidentiality, but the court decided not to take any further action beyond recording what had been occurred. And I think what's probably most important going forward in these situations for lawyers who may have to handle future breaches of embargoes, because let's face it, mistakes always happen. These were the things that were really important to the court. The first was that Government Legal Department had taken all reasonable steps it could have done to ensure the embargo was properly and accurately communicated, that it needed to be abided by, what would happen if it was breached. The court said this actually was not a systemic failure or error case. There was a sensible and robust advice and guidance that GLD had provided. And they also said that once the breach had become known, GLD operated with efficiency and expedition to detect and close it down. And that's something I think going forward we should always be careful of, is when a mistake happens, it's to identify it, try and rectify it as soon as possible, and not to hide it from the court, because GLD did the proper thing of notifying the court about it. And because this was ultimately a breach that was of a single individual who failed to read and observe the instructions, who acknowledged that honestly and openly and apologized for it, the court didn't see any justification for instituting contempt proceedings. But the court did note that in the future it would require full explanations as to how breaches have occurred. So perhaps the lesson from this judgment is something that could have been done that was the witness statement from the individual responsible could have been provided at an earlier stage rather than being requested for by the court. And the court ended by suggesting that if GLD had not acted promptly and didn't have these comprehensive procedures in place, then there may have been a contempt finding, which is interesting. So turning then to a different case, this is a decision of Mr. Justice Chamberlain again. In a different context. This was a claim for reimbursement from Surrey's Drug and Alcohol Service, which was provided in conjunction with the NHS for the provision of a privately medically assisted alcohol detox treatment. Claimants said that they were entitled to this under the relevant policy. Ultimately, the parties in that case said that this required resolution of certain factual disputes, and generally in judicial review the facts are not in dispute. They are essentially matters of agreement between the parties. Perhaps parties might emphasize different facts, but ultimately people are not getting into the realm of he said, she said, etc. That's not really what JR is about. And Mr. Justice Chamberlain summarized the cases on this. There have been a number of cases that look at this, and he said that an invitation to resolve a dispute of fact is sometimes an indicator that the claimant has not actually been able to identify a proper public law ground on which the challenged decision can be impugned. And that's because ordinarily you're focusing on errors of law, not errors of fact. And so if you're really in the weeds of facts, that might suggest you haven't been able to identify an error of law. And then he referred to this wider case law, and in some of the case law, there's this principle that emerges that says that the defendant's written evidence is to be preferred, in other words, to the claimants, unless exceptionally the court permits cross-examination of the evidence, or the evidence cannot be correct. And that is often used by defendants to kind of bolster their own evidence. But what's interesting is Mr. Justice Chamberlain also notes there are equally authoritative statements that put that principle a bit more neutrally and don't see this as a presumption in favor of the defendant. And at paragraph 50 of this judgment, which I think will be quoted henceforth, Chamberlain sort of distills what the principles say and kind of outlines where he thinks this idea of this presumption in favor of the defendant has come from. So the first thing he says is, when a judge is asked to resolve a dispute of fact, is to consider whether the pleaded ground really does require resolution of the dispute of fact. And in most cases, the answer is that actually the resolution of this question is for the decision maker subject to Wednesbury and not for the court. Second stage is, if the resolution of the dispute of fact is necessary, then usually the court proceeds on the basis of written evidence, especially if there's been no application for cross-examination before the start of the substantive hearing. We have seen in the last few years a number of attempts to seek cross-examination of witnesses in judicial review. As far as I know, they've all been unsuccessful. The only time you tend to see this is in cases where you do see properly pleaded error of fact cases, which tend to be in things like age assessment disputes. The third stage is, there is no absolute rule that the court must accept in full every part of the statement of a non-cross-examined witness, whether that be of the claimant or the defendant. A court can reject evidence in a witness statement if it cannot be correct, such as if it is contradicted by undisputed objective evidence that cannot sensibly be explained away, or, and I think this is really the crucial part, if it is on balance inconsistent with other written evidence. In other words, the judge is entitled to attribute such weight as they consider appropriate on the basis of all the material available to them to the various witness evidence that's in the case. The final stage is, if the court is not able to resolve a conflict of written evidence on a question of primary fact, then the court will proceed on the basis that that fact has not actually been proved, which will be to the disadvantage of whichever party asserts the fact. So the principle that the defendant's evidence is to be preferred, save where it cannot be correct, arises because of the difficulty of satisfying this burden of proof where there is a conflict in written evidence. And that's not because evidence adduced on behalf of a defendant is inherently more likely to be true than that adduced on behalf of a claimant. It's because a claimant is more likely to be asserting facts in a judicial review claim. And I think that's the real nuance in the principles that we derive from this case. And I think it's something that defendants need to be cautious of, that they are not simply assuming their evidence is going to be accepted because it's the defendant's evidence, and also a line of attack that claimants can take when this is something raised by defendants. So turning then to a decision of Mr. Justice Swift, and this is in one of the various Arab scheme cases about a former interpreter for the British Army who applied to come to the United Kingdom following the fall of Kabul. I won't get into the details of the judgment, but what's really notable is something that Mr. Justice Swift says right at the end of the judgment about some of the evidence that had been presented in that case. And I think what happened in this case was this was a case that involved closed material procedure, so it is a slightly unusual case from the ordinary run-of-the-mill JR cases. But in this case, in the open evidence, there had been redactions of the names of the civil servants who had written certain documents. It had also extended to job titles and who had written certain documents. And Swift says that these reductions should not have been made. It is one thing for a document that genuinely deals with different matters, some relevant to the litigation, others irrelevant, to be redacted on grounds of relevance. But it is another matter entirely for a document that is relevant to be edited to remove information that goes to explain the document's provenance and context. And he says that this was a common example, so it wasn't just limited to this case, but had been in other cases. And speaking from my own experience in my cases, this is common. When emails are redacted to remove details such as the name of the sender, names of the recipients, or the names of persons copied into the message. He then goes on to say that that should not have happened, and if a party does wish to redact such information from documents that are disclosable in JR, and that what is a disclosable document is a sort of contested idea, but in those situations, an application to the court should be made, and the application should explain the reason for the proposed redaction, and when necessary, set out supporting evidence. And if there's a sort of general practice developing which needs to routinely removing this information, then that should end. And I think this is something that needs to be really thought carefully about by defendants, because I think There are a number of reasons why you might want to redact information, one of which is on grounds of relevance. But what this case, I think, causes you to pause and think about is what might actually be relevant. And provenance and context are something that Swift recognizes might be relevant. So who actually was responsible for this document is something that might be relevant in some cases. But I think the implications of this going forward, I think, remain to be worked through in cases outside of the closed material procedure context. So just finally and very briefly, because we're running out of time, very recent case here, which was about service. And you may recall there is a case currently pending before the Supreme Court, Good Law Project case to do with service. That judgment has not yet been handed down as far as I'm aware. This case sort of was off the back of that. And essentially what had happened is HMRC had a press release which asked for new legal proceedings to be served on a specific email address, which they'd published in response to COVID. In this case, the claimant solicitor had sent a PAP letter, and the PAP response had been sent by a named caseworker at the HMRC. So the claimant solicitor decided to serve that on the named solicitor at HMRC. That's because the press release had also said that for all proceedings, an HMRC lawyer will be allocated in the case, and all subsequent service should be effected on their or any nominated successor's HMRC email address. So they thought that meant the general email address didn't need to be served. And the court found that the documents were not properly served because on interpretation of the HMRC policy, it did require service on that new proceedings email address. However, unusually, the court went on to find that CPR rule 6.15 applied so as to direct that good service did actually take place. And I think what was important here was that the press release was very ambiguous, and the court really criticized it at some length. A lot of the drafting of it, they said it was something that was mandatory, in effect should have been clearer. It was also noted that the claimant solicitor was a seasoned practitioner, that comes up a lot in the judgment, and still misunderstood what the policy required, and that was an impediment to good service. The court then said that while service requires utmost diligence, court equally said that where instructions are purported to be given regarding an important litigation step, they need to be clear, logical, unequivocal, and readily understood. The solicitor also had compelling reasons for interpreting the guidance as he did, and I think importantly, it was that this wasn't a careless slip-up case. He reasonably believed he had actually effected service. He thought he was giving effect to what was required by HMRC. HMRC had suffered absolutely no prejudice because they had been aware of the claim. The only prejudice they faced was the loss of a limitation defense, which is inherent in any of these cases. That's where this case departs slightly from the Good Law Project, because I think the outcome is essentially the same there, that there was no prejudice beyond loss of a limitation defense. So it'll be interesting to see what happens in the Supreme Court on this, but an interesting nuance to that line of case law. So that concludes our presentations, and we now have some time for questions. So Miranda and Sam will be joining us.
Yes, hello. Well, thank you both very much for an extremely interesting and helpful exposition and update of where we've got to on some of the key public law cases in the last few months. That's been excellent. I'm sure our listeners have thought so too. We've got a few questions, but before we turn to those, I'd just like to make a couple of observations of my own, actually, about some of the cases that have been raised today. Insofar as the case that Miranda was talking about, the ECPAT against Kent case, so the children that were being placed in hotels in Brighton by the Secretary of State, that case squarely raises the problem where there are non-derogable statutory duties in circumstances where it is simply impossible for the body under that statutory duty, here Kent, to comply with them. And it may not just be a question of money. It can be a complete lack of physical space or suitable buildings, or it can be even more difficult things to fix, such as if there is simply an insufficient number of social workers, for example. There's a limit to the number of children that one social worker can be responsible for in terms of all the assessments that have to occur. So it does squarely raise that problem, and the solution accepted by the court in the end, in that case, that the Crown could accommodate the children and indeed must exercise that power to avoid a breach of Articles 2 and 3 of the ECHR, albeit only over a very short period of time, is in fact reminiscent of the solution that the Court of Appeal found in Derby City Council against BA, which was last year, which concerned local authority powers and responsibilities to accommodate children in an increasingly regulated world where, for example, there are limits, or strict limits now, in fact, on the type of accommodation that can be provided to children under 16 in particular. And some of you may remember over the last few years various scandals where children in need of one sort or another and looked after were accommodated in caravans or holiday parks for extended period of times in circumstances where that was completely unsuitable. And it's quite interesting because of course, in that context, it's in fact a criminal offence to operate a children's home without being registered under the Care Standards Act. And so and in that case, Lord Justice Macfarlane, who's the president of the Family Division sitting in the Court of Appeal, said that standing back, the reality for social workers and other professionals dealing with young people who are exhibiting behaviour which is dangerous to themselves or others, and where there is a requirement for that behaviour to be safely contained, is that it is often simply not possible to find a suitable bespoke placement which fits within the statutory scheme. It is beyond contemplation that strict adherence to the regulatory scheme should prevent a young person in such a parlous situation being accommodated in a placement that is outside the statutory rules, at least for a short time, if one is available and is the only option for protecting the young person. So it's an example, I think, and we may see that in other spheres where the regulatory regime or the statutory regime is such that there are these non-derogable duties and obligations, but they simply cannot be fulfilled. And then, well, you know, the interpretive obligation under Section 3 of the Human Rights Act may come into play to have to, you know, write in exceptions such as, you know, you can't do X unless failure to do so would amount to breach of somebody's Article 3 rights. So obviously a very high threshold, but I think that that is an area that's worth keeping an eye out for, because in fact, since that judgment, the regime has become even more strict and there are new registration requirements that will have to be done by the end of October this year, for example. So that was one thought about it. And the other judgment that people might find interesting to read and might not routinely come across is a judgment called Al-Nashiri in the Investigative Power Tribunal, and the reference for that is 2023 UKIP Trib 6. It was a case presided over by Lord Justice Singh, who is also president of the IPT at the moment. And the reason it's interesting is because it's all about extraterritoriality and when somebody falls within the jurisdiction of the ECHR for the purposes of Article 1 of the ECHR. And that's, you know, an interesting question for, you know, us, those of us who are a bit legal nerds, but it doesn't rise terribly often. But the reason it's so useful is because it goes over all the stream of cases until June this year, when that judgment was handing down, from Al-Skaini to Bancourt and all the way to much more recent cases. And so, you know, I commend that as a read if you are in a situation where you're thinking about extraterritoriality for one reason or another. So those were my two observations on those talks, but thank you both very much. Oh yes, and one final extremely important one, which is that I'm sure all of you know very well that there is an administrative law guide produced by the court The next edition, I have it on high authority, is due out very soon, but even the 2022 version is incredibly useful and a really good place to start. So if you've got any procedural question in your mind, it's worth going straight to the admin court guide, which is available online and it's free of charge. You can download it as a PDF as well, and start there, because it'll send you to many of the relevant cases.
I totally agree, Sam. It's actually out already. It's dated in the future, but it is available online.
Well, it must have literally just been published then, because I know that it wasn't published not very long ago. Okay, great. Well, no, that's absolutely great. Now we've got a few questions, and let's start with I think perhaps the easier ones, perhaps, in relation to embargoes and judgments. So Charles has set out the position in his talk, but one of the question is, was there any commentary on whether the HMRC policy officer disclosing the existence of the draft judgment was a breach of the embargo in itself, i.e. if they had not disclosed that judgment was favourable, then would it still have been a breach of the embargo, or was the key feature the communication that made it a breach? I mean, just starting from first principles, the existence of a judgment I don't think is a breach of the embargo, but you've got to be obviously very careful not to give any indication as to which way it went. But as to whether there was a discussion about that within that judgment, Charles, can you tell us or help us on that?
There was not. I mean, speaking from my experience, I have had a case where there was a breach of there was a concern there may have been a breach of an embargo because disclosure of the existence of the draft was given. It was notified to the judge by the relevant party, and the judge took no action, which I don't recall the judge saying either way whether or not that amounted to a breach, but I think it indicated that they were not concerned about that kind of issue. The real issue, and if you go back to the Counsel General for Wales case, why these judgments are confidential, it wouldn't really relate to the existence of a draft. It's more about protecting the judicial task and ensuring what, these are circulated primarily, one, to ensure that typographical and really basic factual errors are spotted so they're not in the published judgment, and secondly, to allow parties to prepare submissions on consequential matters. They're not an opportunity to sort of rehash cases, and so that's kind of consistent with that principle.
Yes, I mean, back onto though the core point, if you look at practice direction 40E, it's E anyway, yes, 40E, it's paragraph 2.4, a copy of the draft judgment may be supplied in confidence to the parties provided that A, neither the draft judgment nor its substance is disclosed. And I mean, it seems to me that doesn't obviously cover the existence of a judgment, or for example, that a judgment is due to be handed down in 2 days' time, or whatever it may be. But well, there we are. That's my thought on it. I mean, associated with that, there is the question about whether in some cases people can break embargoes orally. Yes, of course you can break them orally. It doesn't have to be in writing. The prohibition applies, however, whatever the form of communication, it seems to me. Right, then another question is about the publication of policies. Miranda, I think you might have done something on this recently.
Yes, exactly. So the question is essentially, in what context do policies have to be published? And the starting point is not all policies have to be published. Nor is there even an obligation to publish policies, although many judgments have recognised that there are good administrative reasons to do so. In particular, it promotes consistency, fairness and non-arbitrariness in the use of power. The most useful place to go to is paragraph 38 of Lord Dyson's judgment in Lumber, where he says, what needs to be published is that which a person who is affected by the operation of the policy needs to know in order to make informed and meaningful representations to the decision maker before a decision is made. So essentially, if there are relevant criteria as to how you're going to be exercising your power, that probably needs to be in the public domain. There is no obligation, Lord Dyson makes clear, to publish material that would be contrary to national security or other similar interests. And similarly, irrelevant details such as purely administrative matters, of course, don't need to be published. But broadly, if you are telling decision makers how to use their powers, and if it is the type of material about which representations could be made by an affected individual, then that has to be in the public domain, unless there is something like a national security barrier to it.
Yes, thank you very much. There was a request for repetition of a couple of the things in terms of cases. So the case that I mentioned was called Al-Nashiri, and the reference is 2023 UK IP Trib 6. And then the other reference was the Administrative Court Guide. If you type that into Google, you'll get it straight away. Right, a couple of other quick questions.
Can I just say something quickly on unpublished policies as well? Just to say there was another recent case on this in the end of July, judgment of Mr. Justice Swift, in which he says that he found a policy in the asylum support context to be unlawful, which was unpublished. And he stresses it was not unlawful because it was unpublished. It was unlawful because it was ultra-virus. And so I will find the reference for that and share it in a minute. But that's another useful case to go to as a practical. He refers back to the Lumber paragraph that Miranda outlined.
Excellent, thank you. Right, we've got just a couple more points relating to redaction of information in disclosure. Yes, Charles, did you want to kick off on that?
Yes, so there was the question is, can the case on redactions be read more broadly to redactions on relevance grounds generally regarding obscuring the proper context of a document? I think this is where we get into the territory of complication, because what is relevant in judicial review cases is being very heavily contested in a lot of cases. What needs to be disclosed is sort of, you know, what is necessary under the duty of candor is constantly an issue. I think that if the document cannot be properly understood, the context of the document cannot be properly understood, and that is relevant to one of your grounds of judicial review, then it should not be redacted. I think that that's the sort of basic principle. But the question is going to always be who decides what's relevant, and at what stage does that take place. I mean, I've had cases where, you know, it could come down to whether or not a party's interpretation of the law is correct or not, whether or not something is relevant. And you know, the question is, whose benefit of the doubt do you get? Do you have to assume the claimant is right, or do you have to assume the defendant is right on some of these questions? And I think that's an area in which every practitioner would probably benefit from some judicial guidance at some point, and I'm sure it will come up in some case. Yes. There's another parallel question about whether there'll be a change in practice following that judgment of Mr. Justice Swift, because someone's opinion is that in the past, when they raise questions about names of officials, that's sort of been dismissed. So it will be interesting to see. I mean, I have seen disclosure after that judgment, which hasn't necessarily conformed to what the judgment said. So it will be interesting to see whether there's sort of more discussions going on this.
Yes, I think it's going to vary, and I suspect that there will need to be more thought given to redaction in circumstances where what you're trying to do is follow email trails, whereas actually the specific name of a caseworker that took a decision is not very likely to be relevant, and there are elements of GDPR and sensitive information and all sorts of other competing factors, but they're all overcomable in ways to ensure that documents are readily understood. And it's particularly important in email trails, because otherwise you just have no idea who's answering what, and indeed whether it was a different official who got the wrong end of the stick, or exactly what has happened. So I think watch this space is probably the best answer. Excellent. Well, thank you all very much for your time, your attendance, and for your questions. And no doubt, at least some of us may see you next time at the next quarterly update. Thank you very much. Goodbye.